I think we'll go ahead and get started here. Good afternoon, everyone. My name is Kevin Madigan. I'm a legal fellow here at CPIP. Thanks to everyone for sticking around for our final panel of the day. We're going to do this the same as the two other panels that were in this room, in that we'll have one presentation followed by comments by a panelist, then a second presentation, and then also followed by comments. And then we'll leave a little time at the end for discussion with questions from the audience. So first up, we'll be hearing from Professor John Duffy. He is from the University of Virginia School of Law. He'll be presenting his paper titled Patent Equity Lost. Commenting on Professor Duffy's paper will be Professor Renee Leteau-Lerner from George Washington University Law School. After that, we'll have a presentation via Skype from Professor Gary Lawson, who's joining us from Boston University School of Law. Professor Lawson will be presenting his paper titled Appalling Illegal Adjudication, rather provocative title, the AIA through a constitutional lens. And then commenting on Professor Lawson's presentation will be Professor Greg Riley from Chicago-Kent School of Law. And so without further ado, I'll hand it over to Professor Duffy.
Thank you very much. I'm going to stand over here so I can see the slides as I flip through them. So this is a story about a really great period in history that stretched through what I think many people think of as the golden era of the patent system. And there was a certain set of procedures that were used, and they were radically different than what we use today. And I can prove that in a few graphs, to which I'll get to. And so my paper's about that, and there's sort of a very large story arc here. And indeed, the draft paper that's up online only really talks about the very beginnings of this story. But the PowerPoint presentation will lead you through the whole story, which will be written in due course, of course. So here I've got, and by the way, I've got only 17 slides, like 15 minutes, 17 slides. So hopefully I can get through these things fairly quickly. I'm going to say that there's 9 points to this thesis. And that's just so you know that I'm going to end at some point. The first is, 200 years ago, the processes of a trial at law, and that's a term of art. That's not just any trial. It means a trial at law, not equity or admiralty, which includes live testimony, generalist decision makers, and full rights to a jury, dominated patent infringement trials. There was no jurisdiction even in equity for a portion of that time. The failings of that era, and I mean the real deep dissatisfaction with making the processes at law the key decision maker. And in that era, it was the only decision maker because the patent system was a registration system. So there was no even administrative check on this. Everything was being decided by the procedures at law. The failings of that era led to a period in which Congress and the courts shifted power away from the processes of law towards the administrative process, creating administrative examination in 1836, and also towards equity processes. And the result was, after this period ended in about 1870, there was a rather stable process that survived for about a century of using something like equity process not with juries, not necessarily with live testimony all the time. A lot of testimony was, a lot of the procedure was with documentary evidence, and oftentimes without generalist decision makers, oftentimes with something called special masters who had special training, as the name might suggest. So I'm going to show you a few graphs here. This is the yellow or orange line. It's supposed to be UVA colors, orange and blue. Show you that in the beginning, this is a graph of the percentage of cases that were heard by the Supreme Court, infringement cases that were heard by the Supreme Court on appeal, and whether they originated with law or equity. Now you might say, well, looking at the Supreme Court, cases is really just a fraction, a sliver of the cases, and a really unrepresentative set of cases. That's not true in the 19th century, because throughout almost the entire 19th century, the Supreme Court was the Federal Circuit. It had mandatory appellate review over all patent cases throughout the nation. I have an earlier article from 2003 if you want to learn more about that point. So anyway, this is looking at all appellate cases, basically. And so what we see is in this early period, in the first few decades, everything is decided at law, nothing's decided in equity. And beginning in the 1830s, we see a trend away from that fairly dramatically, such that by the time you get to the 1870, you're already over 50% with equity cases. And then equity really begins to dominate. And I'll go forward in time. This is this actually is Supreme Court data all the way up to 1939, which is, of course, the merger of law and equity. But the next graph will show you, these are, since I was Supreme Court cases, this is actually Court of Appeals cases. And Court of Appeals cases really didn't come online until about 1900, a few years before that, but I'm just estimating. And again, you see equities dominating. It's up there above 90% for almost all decades. And law cases are down in the 10% range. So this was a fairly stable system. And that was true, I think, because equity offered three major advantages over the legal system. First, more sophistication at deciding issues of fact, which I think was the first reason that there was this transition. And that actually meant heavy reliance on documentary evidence. And I should say so this is not like a mystery novel. Where I'm going is to ultimately say that the inter partes review is actually a sort of an attempt to get back to some of these procedures. And obviously, those of you who do inter partes review know that, yeah, there's an oral argument, but it's only like, half an hour or 40 minutes long or something like that. It's heavily relied on documentary evidence. That was the way things were decided throughout the golden era of the US patent system. Infringement trials were done at equity, and oftentimes equity had no live testimony. But that's okay if you've got sophisticated people reading these documents, right? Expertise in crucial areas, especially damages through the special master process, and thus, I think, reduced litigation expenses. So that's one thing. There were two other things, which is unification in decision-making, which meant all legal and factual questions were being decided by the same decision-making unit, which could be one judge or maybe two, but in any event, there was unification of decision-making, which meant that the decision-maker had a great deal of flexibility in deciding which issues to decide at what time. And it meant that, for example, one of the things I'm going to say is claim construction actually and validity got bundled and intertwined together in a way that's simply impossible using current practice, but was clearly part of what was going on. And also, I think the equity system was much better at integrating the other layers in the patent system. The agency, most administrative review of agencies today in all other fields is through something like injunctive or declaratory relief, which is an equitable action. And that was true even in the early administrative state, that equity is the normal way you get remedies against an agency. And also, throughout most of the time, there was better integration with the appellate courts because equity process generally followed, for a large portion of this time, followed a rule of de novo review, which is actually kind of interesting. Even on appeal, it was de novo review, which is interesting and I can explain why that was true, but let's just assume I'm somewhat right on that. The equity practice vanished in a quiet revolution, and the precipitate really in the 1970s, late 60s through the 1970s. And the precipitating causes were largely exogenous to the patent process. In other words, no one ever came down and said, you know what, our processes are really working bad in the patent system. We need to eliminate them and fix them. Instead, it was for things outside, really, of patent law. The most important things were two crucial Supreme Court decisions in the late 1950s and early 1960s that were not patent law decisions. Earlier precipitating causes was the merger of law and equity, although that was not so important. There was also change in patent damages law. Again, not that important. It's really these two other Supreme Court decisions that made a constitutional change in terms of Seventh Amendment law. The loss of equity processes had led to a return to an era of patent infringement being dominated by trials at law and deep dissatisfaction with that. Indeed, if you look at the next graph, this is the graph because after 1939 we have merger of law and equity, so I'm just actually using as a proxy trials decided by jury to sort of say that those are ones that are probably using something like equity, old equity practices. And the real sort of switching point is in the mid or the early 80s is when you get a substantial fraction, once again, of patent cases decided by juries. And you should all know that that's the very beginning of expanding re-examination processes, administrative processes. It's the beginning of the march towards greater administrative processes or additional administrative processes. And as you see this grow, you think like, well, again, you know, when things really get to be a high percentage, it's in the late 1990s, we get inter partes re-examination, and then we get inter partes review in 2011, beginning in 2012 and 13. We now see a tailing off, and for a variety of reasons. And I think that this is actually very similar to what we experienced 150 years ago. Or nearly, I guess at this point, almost 200 years ago, when we had this experience with trials at law and we rejected, or there was a lot of problems, and both the courts and the Congress responded with changes to pull decision-making away from the courts at law. And I think that, you know, we should at least recognize this history. I think it is, first of all, it's true that the return to these legal processes generates numerous legal issues. And the most, I'll get to them in a minute, but just as in the early 19th century, discontent has driven decision-making reforms away from these processes at law. And finally, I think the wisdom from this century of relatively stable process should not remain lost, and I think it provides some lessons for the way forward. So prior scholars who've looked at this, or at least written something about it, I don't think there's an article that is focused specifically on this, but Judge Kimberly Moore, when she was an academic here at George Mason Law School, it's then called George Mason Law School, she pointed to the 1870 Patent Act, which allowed damages in equity actions as being a real switch, and certainly that actually pushed people towards equity, because you could get injunctions and damages in equity, and you could only get damages at law. So, you know, which are you going to choose? One where you can get A and B, or one where you can only get B? Well, you're going to choose the process where you can get it all. Chris Beecham actually says, well, that's not really true because the switch happened earlier. It was already precipitating. He identifies, I think, a very important opinion called Goodyear versus Day. Also, other things that he identifies that are occurring around mid-century. I think the thesis of this paper, at least one of the theses of this paper, is that the root cause was even earlier, and the root cause is the failure of the processes of law. And that failure is the same thing that precipitated the shift towards executive branch decision-making. And indeed, if you look at, there are two quotes here. One from the Senate report on the 1836 Patent Act. For you history aficionados, you'll know that as the Ruggles report, after Senator Ruggles. And the second one is from the Goodyear versus Day Circuit Court opinion by Justice Greer. And both of them are sort of saying why they are moving things to, in the first case, administrative law, and in the second case, away into equity. And both of them deal with the competency of the decision makers. We're trying to move things to a more competent decision maker to deal with these difficult issues of science and technology. So I think both of these sort of saw the early, the decision making that was going on in the courts in the early 19th century, and in both cases there was dissatisfaction with that. Once the shift in power begins, I think equity's strength as an institutional integration process was more apparent. It allowed the Supreme Court to control what was going on in patent law, especially but because of the de novo review. It also allowed the Supreme Court to create the presumption of validity. One of the things that's interesting about this is all the cases that people cite as the beginnings of the presumption of validity were equity cases. So in other words, equity was allowing the Supreme Court the freedom to create a rule out of, whole cloth or out of case law to give some degree of deference to the new administrative process. It also is true that because fact and law were decided together, an issue that began to emerge mid-century, which is the Supreme Court in mid-century creates an invention doctrine, what today we know as the non-obviousness doctrine. And it is a difficult mixture of law and fact. And as this doctrine emerges, everything's going to equity. So all the difficulties about how do you separate the fact and law, none of that matters in that era. And for another 100 years, none of that matters. So that is a different, it's a reason why I think the doctrine made sense and was able to be sort of rationally applied by the courts. So I've already talked about this, the various, and since I'm running short on time, this is just a recapitulation with a little bit more detail of some of the things that are the advantages of equity. I want to actually skip through to what happens when we lose equitable processes and we shift back to the processes of trial at law. And a lot of the things we've seen go to the Supreme Court or that people are seeking to get the Supreme Court review over the last 20, 30 years, all of these are the fallout of this incredibly important but yet quiet and unappreciated revolution. So for example, there is an immediate circuit split as cases go to trial with juries about how to divide the law and the fact in obviousness. And in fact, this is still a big issue. It's a big issue you can see in the concurring opinion in an I-4-I case. But it's an important issue. There's controversial law at the federal circuit about it, most recently in the Samsung versus Apple case. The doctrine of equivalence, which is a fact issue, at least is assumed to be a fact issue. I'm not totally convinced about that. But in any event, the doctrine of equivalence, which had been used rather liberally by the courts when they're in equity, as that shifts over to the jury and suddenly the courts think, wait a minute, we're going to give the doctrine of equivalence to unsophisticated juries and tell them it's just an issue of fact? We see actually a severe reaction to that and restrictions on the doctrine of equivalence. The Markman process, I think, is also something that comes out of this. I mean, in the 1990s, as Markman was going to the Supreme Court, didn't anybody ever wonder, why was this not decided before? Claims had been around for more than a century, about a century and a half they'd been required by law. How come it never got decided which part was fact and which part was law? And the answer was, it was irrelevant. It was utterly irrelevant in an era of equity. So I'll go through, I want to wrap up because I think I'm out of time. Okay, so 3 more slides if you'll just indulge me a little bit. I think what we're doing now is we're moving towards a new counter-revolution or reaction against this. And I think the PTAB is one reaction to this. I think that looking at equity, we can actually maybe cajole the PTAB into getting better procedures by saying maybe you should look at the equitable procedures and think about ways in which your procedures are not as good as the old equity procedures, and maybe think about ways in which you can improve your procedures. For example, allowing some live testimony, allowing adversarial deposition of expert witnesses and other things like that. I think the PTAB should think about that. I think BRI, the broadest reasonable interpretation, is kind of a loony thing if you think about institutional integration of the administrative process into the general process, the general legal system. Probably the biggest problem with the PTAB is it's not a unified decision maker because it can only pick out selected issues of infringement, and it lacks power, or selected issues of invalidity, and that is quite a big challenge for this. I think it's the biggest challenge, biggest differentiation for this. I think the courts might consider using some additional doctrines from this era to try to address this process. My final slide, which is the last slide, is just to say look, this thing occurred, this equity system existed, it was stable for about a century during an era that we generally think of where there wasn't a sort of controversy, too much controversy about the processes of the system. The loss of the equity system was not a deliberate decision about patent law, it was really accidental in many ways. The loss has had huge and continuing implications, and at least a sort of partial going back is worth considering, and I think it also seems to be happening. And that is, of course, my final bullet point, which is completely appropriate for a relatively conservative legal academic, which is I want to take you back in time. I want to make patent law great again, okay?
Thank you, Professor Duffy. Professor Lerner.
Well, thank you to Kevin, to Adam Mossoff, everyone who put together this wonderful conference. I am not a patent person, so I feel like an interloper here. My area is juries, which turns out to be relevant to the topic at hand, as Mr. Duffy pointed out. My job is to comment on John's paper, and I will do that in a minute. But first, I'd like to say a few words about Gary's paper. And Greg, I hope you won't regard this as a usurpation of your role. Gary, I think, makes a very convincing argument. In fact, he convinced me that federal adjudication of vested rights belongs as a constitutional matter with Article III courts. And among other things, his paper has a wonderful section in which he rips apart the U.S. Supreme Court's 1986 decision in CFTC versus Shore. With appropriate mockery, I think it's fair to say, Gary discusses the court's reluctance to set limits on executive adjudication of private rights. The court observed, and here's a quote from Shore, the court observed that such limits might unduly constrict Congress's ability to take needed and innovative action. Well, why is such innovative action needed? What Gary does not do, because it's beyond the scope of his paper, is to discuss why there has been such a turn to agency adjudication. And I suggest that the reason is because Article III courts have proved to be very bad at adjudication. They fall woefully short in their core mission, as Gary puts it, the heart and soul of the judicial role to adjudicate private rights. Litigation in federal courts is vastly expensive, prone to delays, subject to inexpert fact finders, with few written decisions on the merits and lack of thorough appeal on the merits. Under these circumstances, it's hardly surprising that many litigants don't want it. It's hardly surprising that Congress has created alternatives. And it's telling that Gary's paper nowhere mentions the main obstacle to decent adjudication, which is the civil jury. I was interested to see that he did mention the criminal jury, but not the civil jury. I think every originalist should urge in the strongest possible terms the repeal of the Seventh Amendment. Madison didn't want it. Hamilton didn't want it. They had good reasons. The constitutional right to civil jury trial is the main stumbling block to effective adjudication in Article III courts. If you want to restore Article III courts to their rightful place in the constitutional scheme, you have to get rid of or find a way around the civil jury. It's no exaggeration to say that the creation of the PTAB was a reaction to the growing number of jury trials in patent cases, which is a perfect transition to Mr. Duffy's paper. The authors beautifully lay out the deep and long-standing misgivings judges have had about lay juries deciding patent cases. But this is not just in patent cases. These misgivings could be repeated for almost all complex cases, indeed almost all civil cases generally. And one of the marvelous things about John's paper is that it addresses the period after the founding, So much work on the jury focuses on the 18th century, when people were still enamored with juries in general because of the struggle against the British government. But the enamoredness wore off. I focused on the 19th century, and by then much of the enchantment with juries was gone, and judges and legislatures were looking for ways to avoid it. So I've been proselytizing for years that people should do more work on the 19th century, and so I was delighted to see that Mr. Duffy has done just that. So John describes the close resemblance of the concerns of Justice Greer in an 1852 case and the Fourth Circuit in a 1964 case. And these are, and I think it's worth repeating these. John discussed these to some extent, but it's worth repeating these, adding a few that John didn't mention in his talk. And first and foremost, concern that the jury will not understand the complex and difficult questions involved. The greater risk of a hung jury because some jurors don't understand the case. The fact that patent cases and complex cases generally do not play to a jury's strengths, such as they are. Those cases do not depend on oral testimony or the credibility of witnesses. Instead, they depend on an extensive written record that needs to be carefully read. It is vastly time-consuming and expensive to go over orally in court all this written material. Trials become too long and confusing. It's very difficult to instruct a jury on law in these cases because it is so complicated. And the authors here, John gives great examples in his paper of these instructions. Now, these were not only concerns of judges 150 or 50 years ago. They persist today, though judges are reluctant to say it in public. They don't want to seem anti-democratic. But I'll tell you this. One federal judge recently told me that sending patent cases to juries was, quote, insane. Another federal judge I talked to used a slightly different word. He said that it was, quote, crazy. The problems are compounded by the lawyers picking over the jury pool, or what we call jury selection. A good friend of mine is a lawyer who tries patent infringement cases almost always for the plaintiff. She says that in these cases, she always tries to strike from the jury anyone who appears intelligent or educated. She says that she's usually successful. She knows that the less intelligent and educated the jury, the more likely they are to find for her client. The jury, therefore, is neither good at adjudication nor does it serve a representative function. After the lawyers are done picking it, it does not represent the community. That's a myth propounded by the trial bar. Nor were these concerns limited to patent cases. Judges throughout the 19th century complained about the time and expense of jury trial, the burden of jury service on jurors themselves, and the lack of juror understanding. And I have a quote here. This is a New York judge in 1862. He says, jurors lack professional education and judicial experience. They act in secret without individual responsibility and are, and this is a quote, far more likely to be swayed by passion and excitement and other undue influences than judges. Jury verdicts are, quote, notoriously many times founded upon mistakes, misconceptions, and other errors. And therefore, it was necessary for judges to review these verdicts with firmness. So, what did judges do in the past about these problems with juries? And as John explains, they set off down the path of turning cases at law into equity. And in this endeavor, they had the help of Congress. Congress expanded equity jurisdiction, including allowing courts in equity to award not just traditional equitable relief, such as injunctions, but also damages. But the story that Duffy tells is a story that in its broad outlines is repeated throughout the civil litigation system in the 19th century. It didn't just happen in patent cases. In all civil cases, judges and legislatures increasingly found ways to tightly control, or better, to avoid altogether the jury. And there were different methods used. So a classic is the technique John describes of turning questions of law into fact. The law grew ever more elaborate, and its subjects included not only the invention doctrine that John describes, but also sufficiency of the evidence, contributory negligence, assumption of risk, and rules about damages. So the growth of the category of law allowed judges to take certain issues away from the jury entirely, or to explain or to constrain them. These mechanisms, as John points out, include the transfer of cases to equity, or the favorite of awarding a new trial. New trials were much more freely given in the late 19th century, so much so that the system became hugely expensive. New trial is a very expensive remedy. And so judges and legislatures were looking for ways to cut off new trials in the case of error. And they found them. These included directed verdict and judgment notwithstanding the verdict. So in patent cases, this happy domination of equity persisted into the mid-20th century. But then, as John describes, along came Beacon Theaters in 1959 and Dairy Queen in 1962. These held that a case should go to a jury even if there were also equitable claims. Now, John, in this version of the paper, does not discuss the reasons for this turn toward juries, so I'm going to offer some thoughts about it. By the late 1950s, the trial bar had started to organize and become a significant political force. The main names here are Sam Horowitz and Melvin Belli. They founded the precursor of the Association of Trial Lawyers of America, or ATLA, and now known as the American Alliance for Justice. The trial lawyers immediately in the 50s began an effective propaganda campaign. They linked the use of civil juries to the Cold War fight against tyranny and communism. If you were against juries, you were a commie. They did this with the help of academics such as Roscoe Pound. By the late 1970s, by the 70s, and that's exactly when John sees the numbers of jury trials taking off, the trial bar was much more aggressive and getting larger verdicts. They had succeeded, in other words, in spreading the word among the jury pool in favor of larger verdicts. And of course, for the trial bar, the plaintiff's bar in particular, larger verdicts, of course, mean larger contingent fees, importantly. So now we are back in an era of more jury trials in patent cases. So the question is, what can be done about this to craft a reasonable system of adjudication? And John suggests, essentially, a return to equity or equity-like forms of adjudication. And this certainly has attractive features, as he points out: decisions by judges, written opinions on the merits, and appeal de novo. Of course, to get there, you'd have to reverse, essentially, Beacon Theaters and Dairy Queen. I don't think that's such a big deal. But even if that were done, and the move toward more equity jurisdiction were found to be constitutional, which is another issue, I have my doubts about whether we would really see much of a return to equity. First of all, as we all know, the trial bar is very powerful. Although I'm somewhat sanguine about that. In certain respects, of course, tort reform has been successful. But the second and more important difficulty is the judges themselves. John describes resistance on the part of trial judges and some appellate judges as late as the 1970s to send patent cases to jury trial. But I fear that such resistance would now go the other way. Judges may well be reluctant to decide such cases. To decide a case on the merits and to write a written opinion explaining one's reasoning is hard work and responsibility. Many judges are and would be happy to avoid it. This is one of the main reasons why judges almost always praise juries, at least in public. Juries, or the threat thereof, relieve judges of a great deal of responsibility. In other words, the responsibility and work that much of the rest of the world considers to be judging. So besides that general consideration, there are special concerns in patent cases. Deciding patent cases often requires technical knowledge or at least familiarity with technical concepts. And many Article III judges lack that. And there's an instructive quote in John's paper from a US Supreme Court decision in the late 19th century, which is arguing for, the Supreme Court is basically saying there should be a commission of intelligent experts and practical men to help them decide these cases. Well, we do, in fact, of course, have a similar sort of commission, and it's called the Patent Trial and Appeal Board. So the PTAB, I have to say, is an astonishingly well-designed system of adjudication. It's amazing that such a thing could actually occur recently in the United States. It really does embody many of the best practices for civil adjudication around the world. Judges with appropriate expertise, a panel of judges in the first instance, strict time limits, which it actually adheres to, written decisions on the merits, and thorough appeal on the merits. So compared with civil jury trial, the PTAB is a procedural Valhalla. The difficulty is, as Gary points out, it may well be, it possibly is unconstitutional and may be held as such by the US Supreme Court in oil states. So what to do? One possibility is taking the judges of the PTAB and making them into special masters, along the lines that John suggested was done in equity, on an essentially permanent basis, and make them salaried. Their findings could be reviewed by a district court in perfectly constitutional Article III fashion. If jury trial is found to be absolutely necessary, then the judges of the PTAB could possibly be made into a special jury. Special juries were well known in England and the United States in the late 18th century. So their use would not violate the original meaning of the Constitution. Difficulty is that even with special juries, it would be hard to require written opinions and thorough appeal on the merits. And these are features that other legal systems consider to be vital to justice. If we cannot have them in our system, that shows the price we pay for being stuck with the civil jury. Thank you.
Thank you. All right, Professor Lawson, you're up.
Thanks so much. Thank you for letting me beam in this way. Renee, to some extent, stole my introduction when she said that she was not a patent person. People my age grew up watching Miller Lite commercials featuring sports stars from Bubba Smith to Billy Martin hawking Miller Lite beer. One of the commercials featured Marvelous Marv Throneberry, who was a symbol of the futility of the 1962 New York Mets, possibly the worst team in the history of Major League Baseball. And Throneberry's commercial was him saying, "I don't know why they asked me to do this commercial." I'm the Marv Throneberry of this conference. I am not a patent person. I'm not an IP person. I'm not even a con law person. I don't study constitutional law. I study constitutional meaning. And as anyone who does study constitutional law knows, the influence of constitutional meaning on constitutional law is generally quite modest. Nonetheless, that's the perspective I bring. So I took a look as a non-IP, non-patent person at the America Invents Act and the PTAB from the standpoint of constitutional originalism. Now, who cares about that? Well, if you hold a patent or you're hoping to invalidate a patent, not you, because that is not what will be used to determine whether or not there is a patent out there. Nonetheless, that's my field of interest, so here's what I found. Now, as a prima facie matter, if you take any random federal agency and look at it through the lens of constitutional originalism, the chances are very high you're going to find it to be unconstitutional in multiple ways. But usually, those are ways that turn out not to apply in this case. Usually, the problem with federal agencies is that they're doing something the national government has no power to do, or there's a blatant subdelegation of legislative authority. That's not the PTAB's problem. There really is a patent power in the Constitution. And while the patent statutes are not necessarily crisp and clean, they're quite far from what I call the goodness and niceness statutes that elsewhere populate the United States Code. No, the problem I found with the PTAB was not with what the AIA prescribed for it to do, but with who the AIA prescribed to do it. The what is cancellation of patents. And the question is, who constitutionally is capable of doing that? And there are two dimensions to that who problem. One is whether courts versus agencies have to do it. And the other is assuming that an agency can do it, what kinds of agency officials can do it. And I think there are problems on both sides. Now, in the paper, I say that one of those problems is obvious, wildly unconstitutional, I call it, and the other is probable. And I stand by that, although as time goes on, I've come to flip the order of which one I think is the wildly unconstitutional part, which one I think is the probably unconstitutional part. I'm going to let you guess which one is which. So let me start first with the who can cancel a patent, agencies or courts. And I'm going to start with the place I always like to start, that's first principle. And the first principles here are that the Constitution is a job assignment, carves up jobs to various people, assigns people certain tasks. You do this, and there you go. And sometimes those job assignments overlap to some extent. For example, if we're talking about handing out veterans benefits, Congress could do that entirely through passing private bills if it wanted to. It could pass a general statute. If it passes a general statute, that could be administered by an administrative agency or directly by the courts, right? So there are certain functions that the government can perform that any of the institutional actors can do. But there are some of the job assignments that are obviously exclusive, right? Only Congress can send a bill to the president for signature or veto, right? Only the president and the Senate can appoint a principal officer of the United States. And only a court, only a judge can preside over a criminal trial. Wait a minute, let's back that up a little bit, okay? We know that the president and Senate can appoint principal officers because there's a clause that says so. We know that only Congress can pass a bill and send it to the president because there's a clause that says so. What clause in the Constitution says that only judges can preside over criminal trials? Trick question. There isn't one. There is no trial presiding clause in the Constitution. So why can't the Secretary of the Navy or the minority leader of the House preside over a criminal trial? And the reason is because when you actually look at the document and start pouring through the different assignments of tasks, it becomes very clear that one of the key levers of that assignment process is the classification of powers as legislative, executive, and judicial. And where does presiding over a criminal trial fit? Well, it fits under judicial and not under legislative or executive. How do we know that? Because the Constitution assumed that people would know that there is some content to these terms, legislative, executive, and judicial, and they would fill that content in honestly. Now, to be sure, the people who drafted the Constitution knew there were going to be hard cases. There's a famous passage from Madison where he says that the line among those powers will pose problems that, quote, puzzle the greatest adepts in political science. So it's not like they assumed everything would neatly sort. But yeah, presiding over a criminal trial, that was an easy case. Everybody knew that. You didn't need a clause in the Constitution to say that. That was a well, duh. And that well, duh, 3 years later got clarified, codified in the Fifth Amendment. which says no person shall be deprived of life, liberty, or property without due process of law. Now, I have a whole other big, long article, twice as long as this one, coming out elsewhere on the original meaning of due process of law. The short version is that due process of law means decision by appropriate governmental mechanisms, meaning decision by the right actors. And what that means is the due process of law, strangely enough coming from the mouth of an originalist, is much more about substance than it is about procedure. It's not about how people can decide, it's about who is the appropriate decisional actor. Procedure matters. People who are deciding have to do it in a process that is appropriate for their task, right? But you don't satisfy due process of law by having the wrong actors use the quotation marks right procedures. The Secretary of the Navy can't preside over a criminal trial, even if there's a jury, even if the Secretary follows all the rules of evidence, even if there's compulsory production of witnesses, all the bells and whistles. No, you gotta have the judge, right? As Marvin Gaye and Tammy Terrell put it so eloquently, ain't nothing like the real thing, baby. For due process of law, which didn't add anything but simply codified what was already implicit in the Constitution's allocations, the real thing means a judge. So the question is whether canceling a patent without an exercise of eminent domain by Congress, which is a whole different story, is canceling a patent something that only a court can do, just like presiding over a criminal trial. And the short answer is, if it is a vested property right, then the answer is yes. How do we know that? Because that's what it means for a property right to be vested. That's what it means for property to be deprivable only with due process of law. That's the difference between a right and a privilege, a distinction that was blatantly obvious to everyone in the constitutional world up through the 1950s. Okay. Modern due process law, which focuses not on who decides, but whether the wrong deciders have used good enough procedures, is completely and totally wrong. Now, at least it's wrong with regard to the Fifth Amendment. It might actually be a plausible guess about the right meaning of the 14th Amendment, but that's a different story, focusing here only on the national government. Now, all this stuff that I've said that sounds bizarre to a lot of modern ears, the 19th century courts knew exactly what they were doing, and they got it right. Not so much in the context of invention patents, but land patents. There were a ton of cases in the 19th century about land patents and whether they were valid and who could decide that and how they could be canceled. And the 19th century courts got it exactly right. As long as it hasn't issued yet, the executive agencies can recall it and reconsider it and do anything they want with it. Once the land patent issues, it's a vested right. And at that point, only a court can declare it invalid. That is the context that patent scholars will recognize as leading up to the McCormick case, right? Which is a whole nother story. So once we're dealing with vested rights, the Constitution specifies who it is that is supposed to be undoing those vested rights. That would be Article 3 courts. Whether that requires a jury, that's a whole nother story, but it's got to be an Article 3 court. All of which leads to the, I would say 6 million, but it's more like $6 trillion question. Are patents vested rights, or are they more like veterans' benefits? Well, that's where my introduction comes in, and I assume the guise of Marv Throneberry. You folks tell me, you're the patent experts. I can set out the framework here, but am I the one to decide whether patents are vested rights or not? No. Looks to me like they probably were, at least until 2011, but that's a whole different story. We'll leave that for the comments and discussion. All right. Well, that's problem number one. That's the one I started out thinking was a slam dunk. But the more I thought about the vested rights problem, the more problematic I am about drawing strong conclusions from it. The second problem, the more I think about, the more convinced I am is more serious, although it's fixable. And that goes to assuming that the PTAB is an entity capable of canceling a patent, who within the PTAB or what sorts of officials in the PTAB can do it? And the background here, and this is appropriate for this panel, is the Duffy defect, right? Something which struck one of the predecessors of the PTAB when its members were not appointed in a manner appropriate to officers of the United States. Professor Duffy now has a constitutional doctrine named after him. I will be forever jealous until I get one. All right, so all the members of the PTAB are now appropriately appointed as inferior officers of the United States by the Secretary of Commerce, with one exception, and that is the director of the PTO, who is appointed as a principal officer. So now we have a PTAB full of officers, one of them principal, the rest of them inferior. Here's the problem that I see. The PTAB can only act in groups of 3. Which means even if the director of the PTO is on every single PTAB panel that is ever convened, at least 2 members of that panel will be inferior rather than principal officers. I think all of the PTAB members have to be principal officers, and here is why. What makes an officer inferior or principal? Well, the Constitution, as with so many things, doesn't tell us. It says that there are inferior officers and then non-inferior officers, but it doesn't specify how to draw that distinction. And modern courts have been all over the map on this. Morrison versus Olson, the Supreme Court, mixed and stirred and squished and squashed, and you throw this over here and you bring in Emerald and bam, and that's how you know whether you have a principal officer. Justice Scalia wrote a ferocious dissent, which a decade later morphed into a unanimous majority opinion, albeit arguably dictum, right? In which the focus shifted to the hierarchy. If nobody supervises you, you don't answer to anyone, says Justice Scalia, you've got to be a principal officer. And about 10 years ago, Steve Calabresi and I wrote an article that argued that as a matter of original meaning, that's pretty clearly right. And I'm not going to go through that entire analysis here. More fundamentally than that, what does it mean not to have a superior? The thing about the PTAB, based on my reading of the statute, is once it issues a decision, there is no other entity within the executive that can review that decision. The PTAB itself can review decisions of the PTAB, and the Federal Circuit can review decisions of the PTAB. And if one believes in the unitary executive, the president can always review decisions of the PTAB, but no other executive official. The Secretary of Commerce can't review decisions of the PTAB. So the PTAB's panels of 3 are making decisions that are internally within the executive department final decisions. I think that can only be done by a principal officer. And that is true even if the people making final decisions can be removed by someone else, because removing them doesn't undo their decision. To undo the decision, you then have to appoint somebody else who could then undo the decision. But as long as the previous actors can make legally binding decisions on behalf of the executive and no one else can review those decisions, I think that has to make them principal officers. And if that's what the members of the PTAB are doing, well, even if they can do it as agency officials, even if we've solved the Duffy defect, that still leaves what I will now call the Lawson lacuna. And that is that they need to be appointed by the president with the advice and consent of the Senate in order to carry out that function. There is one possible out on that, although I think it doesn't work as a matter of statutory interpretation. And that's to say that the PTO director, the one principal officer in this whole mix, can actually substitute his or her views for those even of 3-member PTAB panels. There's a non-frivolous argument from the text of the statutes that'll get you there. I think it's too cute by half, and although I'm generally sympathetic to arguments that are too cute by half, this one I don't think makes. All right, time is up. Thank you very much. I look forward to the comments of Professor Riley.
Thank you, Professor Lawson. Professor Riley.
Well, I'm very excited that Professor Lawson has contributed this analysis of PTAB adjudication. Too often, constitutional law theorists and admin law scholars have ignored patent law, and I think largely to the detriment of patent law. Professor Lawson's analysis brings a level of nuance and sophistication to an argument against PTAB adjudication that we largely have not seen from those making arguments against the PTAB's adjudication. So I'm going to focus in on this question of cancellation of vested property rights. I don't have much to say on the Appointments Clause issue. I have trouble getting too excited about it, other than to point out that this issue of director review seems to be a recurring theme throughout these papers, with some suggestions that director review is problematic and others suggesting that the absence of director review is problematic. Okay, so to organize my thoughts, I have two alternative titles for Professor Lawson's paper that I think better summarize what he's trying to get at, and I'm going to talk about each of them. So first, I want to talk about this concept that there's nothing in his paper that is specific to the PTAB or the AIA. His argument is not that there is anything particular about the PTAB or different about PTAB administrative adjudication from the rest of administrative law and the rest of the administrative state that makes it uniquely constitutionally problematic. In fact, he's quite honest. His concern is with the past 8 decades of Supreme Court precedent, which he believes departs from the original meaning of the Constitution. And he is equally clear that under the existing doctrine, the past 8 decades worth of Supreme Court precedent, PTAB adjudication, inter partes review, are perfectly, I shouldn't say perfectly, are almost certainly constitutional. Put another way, if patent law is subjected to the same standards as other areas of law, there is no problem with PTAB adjudication. Now, of course, Professor Lawson is also quite clear that he doesn't care about what the outcome is under existing doctrine. That's not his focus. His focus is on what he thinks the outcome should be under what he believes to be the true and correct constitutional meaning. And that's his job. That is his role as an academic, in part, is at least to say what the law should be, not what the law is. And his paper makes a useful contribution in that regard. The problem is that Professor Lawson is writing in an environment in which this issue is highly salient. People have their own normative objectives and their own interests. And there is a danger that people who lack his nuance or intellectual honesty will mistake or misuse a paper about what the law should be as being about what the law is. And many opposed to PTAB adjudication contend that Congress acted unlawfully in creating IPRs, that the Federal Circuit erred in upholding PTAB adjudication, and or that the PTAB adjudication is inconsistent with Supreme Court precedent. Professor Lawson's paper shows that that is not the case. It confirms that in order to strike down PTAB adjudication in the oil states case, the Supreme Court would have to do one of two things. The first is to treat patent law different than every other area of law and subject the PTAB to different standards than other types of administrative adjudication. Or it would require an act of judicial activism by the Supreme Court that would ignore or undo the past 8 decades worth of precedent. There is certainly nothing wrong with advocating one or both of those two results as long as you're honest about what you're doing and what the limits are to your argument. So here, largely my concerns are not at all with what Professor Lawson writes in his paper, but how, in this current environment and the salience of these issues, others will try to use his arguments. I do think, however, that there are 2 ways in which the way the paper is written, at least in its current draft form, contributes to this problem in the danger of misuse of his paper. And the first is the rhetoric. Appallingly illegal, wildly unconstitutional. Now, in general, that's a lot of rhetoric. I don't mind big rhetoric. The problem is the analysis doesn't really support that. What the analysis shows is that PTAB adjudication is perfectly consistent with governing doctrine. Professor Lawson may say that that governing doctrine is illegal and unconstitutional itself because it departs from the true meaning of the Constitution. And that's perfectly fine. But the problem is that is not how most people use illegal and unconstitutional. It is Professor Lawson's prerogative to say what the law should be. In our system of government, it is the Supreme Court's role to say what the law is. And I think most people would think when you say if something is consistent with Supreme Court precedent over the past 8 decades, it is legal and constitutional. Now, I don't want to belabor this point. I'm getting into general issues related to originalism that are beyond my expertise. And I'm sure Professor Lawson has heard this criticism before and has an articulate response to it. But that doesn't mean that it's unimportant to point out this move from pointing to inconsistency with the original meaning or one's belief about the true meaning to then saying that it is illegal and unconstitutional. Because Professor Lawson has a minority view as to what it means to be illegal and unconstitutional, and that minority view could lead to confusion, again, in this highly salient, when his work is being put out in a highly salient environment. The second problem is that actually his analysis, as he identifies today, doesn't even allow any conclusion regarding the PTAB or the AIA. In his introduction, in the title, he calls it legal adjudication. He says this is wildly unconstitutional in his introduction. But then when we ultimately get to applying this to patent law, he leaves the question of that kind to patent experts. Certainly, again, the prerogative. It's not his field. That's a perfectly reasonable thing to do. But it's unclear to me then how he can draw the conclusion in the introduction and in the title that it is illegal or unconstitutional when it is not even applied to the AIA or PTAB, at least in this current draft form. And that relates to and brings up my second point. And that is that Professor Lawson's paper, actually, even under his own understanding of the constitutionality of administrative adjudication, establishes that PTAB adjudication is perfectly constitutional and perfectly legal. Definitely for patents issued or filed after 2011, very likely for patents issued after 1999, and likely for patents issued after 1980. In this part, I'm going to accept Professor Lawson's understanding of the original meaning of administrative adjudication and simply apply it on its own terms. And the key passage in this regard is his recognition that the statutory scheme could create property rights that are conditioned on, that are defeasible, that are conditioned on an administrative determination to cancel those patent rights. And if the statutory scheme does that ex ante, it creates a property interest that is conditioned, that is defeasible, conditioned on administrative cancellation, rather than creating a fee simple absolute scheme or the like, then there is no problem with administrative adjudication, even under Professor Lawson's vested rights theory and his theory of the true meaning of the administrative adjudication under the true meaning of the Constitution. When he applies this to patent law, he suggests it's not his understanding of the content of invention patents, that they are defeasible by administrative adjudication. And I would suggest that in this regard, he is mistaken. So, 35 U.S.C. 261 expressly makes the property right created in a patent subject to the other provisions of this title of 35 U.S.C. Justice Thomas's opinion in eBay likewise made that recognition that the property interest created in a patent is subject to the other provisions of the Patent Act. Since 1952, the other conditions of 35 U.S.C. have included the possibility of administrative cancellation of patent rights. That is, the property interest has been limited, has been conditioned, has been defeasible based on administrative cancellation. In 1952, it was in the form of interferences. 1980, it was in the form of ex parte re-exams. 1999, it was the form of inter partes re-exams, and importantly here, the ability to file a de novo district court action was eliminated in 1999, such that the level of judicial involvement as of 1999 was the same as under the AIA. And then in the AIA, we have the new procedures that allow for cancellation. We can debate when the conditions imposed on patent rights became sufficiently similar that, to satisfy the constitutional concerns Professor Lawson has under his understanding of the Constitution. The Supreme Court in Cuozzo suggested it was 1980, though a reasonable argument could be made it was 1999 when the level of judicial involvement became the same. And some would certainly argue it's 2011 because IPR is different than prior procedures, though I'm skeptical that those differences have constitutional significance in this regard. But in any event, we're arguing around the margins. Those margins are definitely important margins for some patentees, but the point is, even under a very restrictive view of administrative adjudication provided by Professor Lawson in his paper, PTAB adjudication is constitutional for all future patents and some, most, or all of issued unexpired patents. Now, of course, you could suggest that I'm not taking Professor Lawson on his own terms. That is, that Professor Lawson is concerned with the original meaning and not with the current state of the law. And even if the current state of the law is that patent rights are defeasible, they do not provide a fee simple like interest, they're defeasible by administrative adjudication. Maybe that's inconsistent with the original meaning of patent rights. Maybe that is that the original meaning of patent rights requires indefeasible fee simple like rights. Now that would be a little odd. Patent rights are limited in term to start with, nor is there any evidence that the original meaning of the IP clause would require indefeasible fee simple like rights. Certainly, the statutory scheme as it developed by the middle of the 19th century and remained largely through the 20th century was a system of fairly strong patent rights that looked closer to the kind of indefeasible vested fee simple like, however you want to phrase it, rights that Professor Lawson is concerned about. But that's not evidence of the original meaning itself. In terms of the evidence of original meaning, again, working a little outside of my area, we have to start with the idea that patent rights are strictly creatures of statute. They do not reflect underlying rights that existed without the statutory scheme. And therefore, the nature and scope of the property right is determined simply by statute. And we know although there was no non-judicial cancellation of patents in the United States before 1952, we know that the environment in which the IP clause was enacted was very familiar with non-judicial cancellation of patents. It happened in the Privy Council in England, happened via state and colonial legislatures, and it happened, there was a petition to cancel a patent in 1794 in the United States. Moreover, we also know that the framers did not see patents as necessarily being fee simple like rights. They imposed or proposed to impose all different types of conditions on patent rights that look very different than the nature of the property interest as it had developed by the middle of the 19th century. So, for example, in debating the Patent Act of 1790, the Senate amendment proposed, there was a Senate amendment proposed that would have required compulsory licensing, price controls, and working of the patent as a condition on the patent right. Similarly, the experience of a non-resident patent, resident alien patentees show the way in which Congress can condition and restrict the nature of the property interest granted. This ultimately culminated in 1832 when Congress imposed a working requirement on non-resident aliens and provided that the patent would become absolutely void without resort to any legal process to annul or cancel the same. Now, I am not making the contention that these kind of defeasibility conditions are exactly the same as saying that a patent right is defeasible based on an administrative determination, as has been the case since 1952. All I am suggesting is that there is no evidence, and in fact, evidence to the contrary, that there is some sort of constitutionally enshrined, mandatory, indefeasible right that cannot be subject to revocation outside of outside of the judicial branch. That is, when Congress created patent rights, when the Constitution created patent rights, it gave Congress the power to define the nature of that right granted. And since 1952, that right has been one that is defeasible based on an administrative adjudication.
Thank you, Professor Riley. Thank you to all the panelists for their presentations and comments. We're running a little over time, so I think I'll go ahead and open the floor to questions from the audience if anyone would like to ask. Sir?
So a question for Professor Lerner. The history you gave of outside the patent system of the civil jury and its discontents is really interesting, and I'm curious to know the attitude in the judicial branch and among the practicing bar towards civil juries. Was it at all influenced by what questions, the nature of the questions that the jury was actually being called upon to answer? Because I can imagine, particularly in the civil context, most cases that we now sort of think of as civil cases either sound from a remedial perspective in contract or in tort. You're either trying to put somebody in the sort of expectation position or the original position, the reliance interest being vindicated. If it's a question of tort, the jury seems less problematic based on your explanation, because you're not really calling upon them to engage in the sort of transactional economic expertise questions. It's more about just ordinary social human judgment, to which they have no worse access, certainly, than a judge might. Whereas in the case of contracts or other complex matters, the jury might be less well situated to do that.
Yeah, and the concern was really across the board for civil juries, and it took different forms depending on the type of case. So you're certainly right about that. The concern was, even simple debt cases. That's what dominated the docket in the first part of the 19th century, just basic debt cases. And the idea there was, it's just too time-consuming and expensive to send these things to juries. These are simple cases. The damages are clear. Usually the defendant has no defense. Let's just do these in summary fashion. And that was the origin of summary judgment, in fact, was in those kinds of debt cases. So even a simple case like that, people's like, it's just too much. And the burden on jurors themselves, this is a recurrent theme in the 19th century. And this is something that we forget, because essentially we have no jury trials today, right? Hardly any. When's the last time you got called for jury service? Right.
I served on a jury in college, but that's not.
All right, but I assume, pardon me for making this assumption, that it was some time ago. Right. The fact is, most of us are not called regularly for jury service. If we were, we might have a different view of the burdens of jury service. But in any event, contract cases, absolutely. Judges were very frustrated with juries in the 19th century because of their incompetence dealing with questions of damages. That judges and jurors differed considerably in their view of what damages should be. And judges were frustrated that jurors were not following their instructions and were not coming to reasonable results in contracts cases. Tort cases. That was a major flashpoint in the late 19th century, and there the civil jury became a major political issue. The reason is the Industrial Revolution, manufacturing processes, and especially railroads. Railroads caused much damage, many personal injury actions against railroads. Railroads were also, in many places in the United States, hugely unpopular. So you had juries who were very bound and determined to find against the railroad, pretty much no matter what the evidence was. And so there you had very severe clashes between judges and juries on those kinds of personal injury issues. And that's where you saw the development of directed verdict, for example. Judges were just saying, we're awarding too many new trials. This is too expensive. We just have to cut this off. That's what happened there. Also, increasingly, those personal injury cases, there were expert witnesses involved. There were somewhat complicated technical questions about the braking systems of railroads and even damages. And so the concerns about juries were across the board in all cases.
Thanks.
Can I just comment on that one?
Please.
Is that the most interesting thing I found is that in the equity cases, the use of special masters was a controversial point, except for damages. And that I think is very interesting because Chief Judge Rader actually for a long time gave presentations where he said, if we could just get damages right in patent law, a lot of other controversies would drop out, the problems with trolling and things. And I never totally agreed with that, but I actually thought he was, pretty much right, that if you had reasonable damages calculations, maybe a lot of the controversy would go away. And the special masters were, if not expert in patent law, they at least were people who had a lot of business training, who could try to bring some degree of expertise. And right now, the Federal Circuit is trying to encourage judges to use, Daubert and other things to sort of cut down on the sort of junk science or junk damages expert testimony to go to the jury, which is another way to sort of say, oh, we got this jury, we've gone too far, and we're trying to reel it back now with judicial supervision.
Adam?
Well, Greg has thrown the gauntlet down pretty strongly on Gary, so trying to hoist Gary on his own constitutional petard. So I would love to hear Gary's response, if not for at least a couple minutes.
That's fine. It's pretty feeble. I agree with most of what he said. No, I would definitely, the next draft is going to read a little differently. When I first wrote it, I was more confident than I am now about the Article 3 due process aspect of the piece and less confident about the appointments clause piece, so I'll switch it. I'm definitely going to change the title. It was the best play on AIA I could come up with on short notice. With a little bit more time, I will definitely do better. But no, on the substance, the two concerns I have, and I'm going to have to work this out in the next draft, are this. Even if one has conditions baked into the grants of patents, the conditions that were baked into pre-2011 patents would have been pre-2011 conditions, not AIA conditions. So even if it is possible to conceive of patents as defeasible in this sense, the things that would make pre-2011 patents defeasible would be the things that were incorporated into the pre-2011 statutes. So it would still be unconstitutional to apply these new conditions that weren't part of the original grant to patents issued before 2011. That's concern number one. My concern number two is I'm the one who raised the analogy between land patents and invention patents with the idea of defeasible interests. There is one big difference between them that I haven't worked out yet, and that's this. When the government is granting a land patent, it is actually conveying away something that the government owns. In the words of Article 4, territory or other property belonging to the United States that is being disposed of. So that creates one set of institutional arrangements where the government can convey part of what it owns and keep the rest. When the government secures a patent, even if there is no sort of underlying natural constitutional conception of a patent right, it's still not the case that the government is conveying away something that it has. It's doing something different. Now, whether that changes what you can bake into the grant, that's something I haven't worked through yet. I'm hoping that it doesn't lead me into the world of unconstitutional conditions, because I don't have a theory of unconstitutional conditions, and I don't particularly want to work one out in this particular context. But Professor Riley, I think, is right that there's that there's more to this than the current draft indicates. I think that's absolutely correct, and I'm grateful to him for his input on this.
So just to follow, this is Greg, Gary. Just to follow up, one on your second point, there is actually a 19th century case, and I can't remember off the top of my head, late 19th century case that made that exact point as you did between land and invention patents, the difference between them, and actually used it as a reason to be more concerned about fraud and obtaining invention patents because it wasn't just the government's own thing, it was the public's. I'll send that to you. Then the question I had for you is your perspective that it doesn't matter how similar the condition was pre-2011? That is, let's just say for hypothetical, the nature of the condition imposed on patent rights prior to 2011 was 80%, 85% the same as the condition imposed by the American Invents Act.
I don't think
similarity doesn't matter, any difference?
No, I don't think it makes any difference. And there, the analogy to land patents would work. Whatever conditions you put into the land grant, you can't add them and say, well, it's kind of like you grant someone a defeasible interest, and then you try to exercise, a right of entry or whatever the future interest is that you've retained. And no, they haven't actually violated any of the conditions in the original grant, but the thing they've done is sort of kind of like it. No, that's not going to work. You're not going to be able to undo the interest based on that. So I do think it has to be isomorphic.
Professor Duffy?
So I have a question then. Let's assume, and I think the timing on this is that the patent in oil states was actually granted after the inter partes re-exam process, which was an administrative revocation, inter partes. It was different, but not in any constitutionally meaningful way. So your position would be that that proceeding could still be used against this particular patent, not the new inter partes review proceeding, but the old inter partes reexamination, which is highly similar, I think 80 or 90% similar, but it could be. And if that's true, I don't think that argument has been made by the petitioners. In other words, I don't think they're saying it is totally constitutional to apply to us old inter partes proceedings. It's just that you got the wrong proceeding against us.
Yeah.
And so that might be an actual,
very few things that I've
being
ever
persnickety lawyer here, but I always encourage my students to be a persnickety lawyer. So, but then I have another question here, which is that the patent statute actually, if you want to analogize things to land, I think, and I have a brief on this, an amicus brief, it seems like you would, if you could analogize it, and they're very different, not only because the government owns it, but the government owns it under state law. The land title that they convey becomes state rights. If you give me a land grant, that land grant ultimately has to fit into the state property law system. Right? If I build my house on, if I convey it to somebody else, it's all state law which governs that right, which is perhaps different than this. But anyway, if you were going to make an analogy, it seems like you might consider making the analogy to leases, which have always, or at least been for more than a half century, I think about 60 years, subject to administrative revocation under Supreme Court precedent. And the patent statute actually says that patent rights are personal property. And leases are personal property, they have this they're like land, they're interests in land, but they're actually under the common law, they're personal property. Does that statute, which actually the petitioners rely on, but also my amicus brief relies on, and says actually that they should have read that statute a little bit more carefully and said, hey, all we're getting is personal property, and that is subject to administrative revocation, and therefore they should have known that that's one of the things we're getting. We're just getting personal property, not fee simple.
Yeah, I mean, is the question whether that makes a difference in the analysis, that it's personal rather than real?
Right,
my
it's an original matter, right? Because
my instinct is no. The land analogy struck me only because I teach property and I knew the land cases and I didn't know the patent cases, but. I don't know that it makes a huge difference whether it's real property or personal property, as long as it's a right. I mean, when Article 3 talks about property, it doesn't distinguish personal property from real property. Property is property. And whatever principles govern what you need if you're the government in order to deprive someone of property aren't going to depend on the form that it takes. So I'm not inclined to see any constitutional significance to that. There might be some historical significance that would make it interesting when one looks at the older cases.
Right.
But I don't think it makes a difference in terms of the constitutional analysis.
Thanks. I think we're going to have to leave it at that. We're just about out of time. I want to leave a couple minutes for Adam's closing remarks, but before that, I wanted to thank my panel.
Thank you.